Now, the next issue that I want to go over is the question of a tenant renting out their unit on a short-term basis. The city's regulations clearly do permit a tenant to do so, as the definition of a principal residence includes a property owned or rented by an individual person. The city's guidelines for tenants, however, simply advise that you should be aware of your responsibilities under the Residential Tenancies Act and your lease agreement with your landlord. There are many stories over the past few years of a landlord discovering that they rented out their unit, thinking that the tenant would be living there themselves, only to find out that the tenant was listing it on Airbnb or another platform. There have been cases where individuals were effectively running an entire business on this basis, renting out multiple units across the city and then listing them all on Airbnb. The first thing that's important to note is that Section 134.3 of the Residential Tenancy Act does prohibit a tenant from subletting a rental unit to one or more persons where the rent collected is greater than the rent that they're paying to the landlord. Depending on the number of rentals and the rate charged, a tenant could violate Section 134.3, which does constitute a ground to terminate the lease. There is also the question of whether renting on a short-term basis constitutes a sublet, which would require the consent of the landlord in accordance with Section 97 of the RTA. Again, I don't believe that this question has been considered in a reported decision following the enactment of the new regulations, but subletting is broadly defined in the RTA as a tenant vacating the unit, allowing another individual to use a unit for a specified period of time, and then that tenant returning to the unit. While a landlord cannot arbitrarily withhold consent to allow a tenant to sublet, in most circumstances, a landlord would likely have a reasonable case that there are valid concerns against providing consent for a short-term sublet through a commercial platform. On that basis, a short-term rental of an entire rental property would likely be caught under the RTA's definition of subletting, and accordingly a violation of those provisions, and like the provision of some leases, if the landlord's consent for that entire unit short-term rental is not obtained. Now, the other question is the rental of 1 to 3 bedrooms in situations where the tenant's going to remain in the unit during the period of the rental. And this is a little bit of a more complicated question. Well, Ontario's new standard form of lease for rental property prohibits any restrictions on allowing any guests, roommates, or additional occupants. Renting a single bedroom on a short-term basis likely properly doesn't fit with any of these categories.